Generally, mortgages are subject to a state's Recording Act, which is a law that provides public notice of property interests and determines the relative priority of competing property interests. However, a purchase money mortgage, which is a mortgage issued to the buyer as part of the purchase price, takes priority over all other claims or liens, even though the other claims or liens may have been recorded prior to the purchase money mortgage. But what if the vendor, that is, the seller of the property, and a third party both have purchase money mortgages? Does the vendor's lien have priority over the third party's lien? The Colorado Supreme Court considered this question in ALH Holding Company versus Bank of Telluride. In 1993, ALH Holding sold real property to two buyers for $165,000. As part of the sale, the buyers borrowed $110,000 from ALH in exchange for a promissory note secured with a vendor's purchase money deed of trust. In addition, the buyers borrowed the remaining $55,000 from the Bank of Telluride and signed a promissory note secured with a purchase money deed of trust. ALH and the bank each knew, prior to closing, that the other would be loaning money to the buyers for the purchase and that both loans would be secured by deeds of trust on the property. Telluride Mountain Title Company then closed the transaction for both parties. The next day, the title company recorded the bank's deed before it recorded ALH's deed. Subsequently, the buyers defaulted on the loans, and the bank initiated a foreclosure sale, representing that its lien on the property had priority over ALH's lien. ALH then sued the bank in state district court, seeking a preliminary injunction to stop the sale and a declaratory judgment that its lien had priority over the bank's lien. Following a hearing, the court entered judgment for ALH, concluding that under Colorado law, ALH's lien took priority over the bank's lien. The bank appealed to the Court of Appeals, which reversed, concluding that under Colorado's race notice statute, the bank's lien was given priority because it was recorded before ALH's lien. ALH appealed to the Colorado Supreme Court.